Welcome to POSH Judgements, your window into the latest court rulings shaping workplace dignity and safety across India. Stay updated as we bring you real cases, real decisions, and lessons that matter, because awareness is the first step to prevention.
Welcome to POSH Judgements on Metis POSH Radio, India's first radio for POSH awareness. In this series, we revisit landmark cases that shaped India's understanding of safety, dignity, and justice in the workplace and beyond. Today's story takes us to the Bombay High Court, where a peculiar question was asked. Can a comment about someone's hair qualify as sexual harassment? The case, Vinod Narayan Kachave versus the Presiding Officer, Internal Complaints Committee, and another. Judgment delivered on the 18th of March 2025 by Justice Sandeep V, Marne. It began when a woman filed a complaint of sexual harassment against her colleague, Mr. Kachave. Her complaint listed 3 incidents. First, he said to her, "You must be using a JCB to manage your hair," and then started singing a song about it. Second, he made a vulgar remark about a male colleague's private parts, joking about whether his machine was working. And third, she alleged that her reporting manager watched her and discussed her attire with male colleagues. The internal committee conducted an inquiry. Based on witness statements, they held the petitioner guilty under the POSH Act. Mr. Kachave appealed to the industrial court. His appeal was dismissed. He then approached the Bombay High Court. The key question before the High Court was this: did the JCB remark amount to a sexually colored comment, one that falls under sexual harassment as defined by the POSH Act? The court examined the evidence. It noted that the comment was made in June 2022, and afterward, the complainant and the petitioner exchanged friendly messages. In one, he praised her performance. She thanked him in return. The court observed that the complainant herself did not seem to treat the comment as harassment when it was made. It said the remark did not appear to have been made with sexual intent, that it seemed more like workplace banter or casual motivation. As for the second allegation, the court pointed out that it involved another male employee and that the complainant wasn't even present. And the third allegation, the court said, had nothing to do with the petitioner at all. The judgment also criticized the internal committee. It said the IC had failed to match each charge with specific evidence, calling its findings vague. Its report, the judge noted, merely claimed that all serious allegations were confirmed, without explaining how. Even the industrial court, the judge said, had failed to consider whether the alleged actions, even if proven, could legally amount to sexual harassment. In conclusion, the Bombay High Court held that the allegations were neither proven nor met the legal definition of sexual harassment. The findings of both the internal committee and the industrial court were declared flawed and perverse. The petition was allowed. But the case didn't end with the judgment. It raised bigger questions about how sexual harassment is interpreted in Indian workplaces, questions about intent versus impact. While the court believed there was no intention to harass, the broader principle of the POSH Act focuses on how conduct is perceived by the aggrieved person. Courts in earlier rulings, including Dr. Punita K. Sodhi versus Union of India, 2010, have emphasized that it's not intent alone, but the impact on the complainant that truly defines sexual harassment. In this case, that crucial element of impact appears to have been overlooked. The court also didn't comment on professional conduct. The fact that making sexual jokes about colleagues, even in jest or in the absence of the complainant, reflects poor workplace decorum. The order, some say, focuses too narrowly on the letter of the law while missing its spirit. The POSH Act was designed not only to punish explicit harassment, but also to build a culture of respect and sensitivity at work. And so, while Mr. Kachave was cleared, the case leaves behind an uncomfortable question. Where do we draw the line between casual workplace humor and conduct that chips away at dignity? You've been listening to POSH Judgements, real cases, real laws, real questions about respect and responsibility at work.
This was a simplified summary of an actual court judgment, created to help listeners understand the essence of the case and its relevance to workplace safety and POSH law. It is not a verbatim reproduction of the official judgment, and certain details have been adapted for clarity and ease of understanding. If you wish to read the complete judgment, along with all cited laws, sections, and case references, please visit www.metisposh.com.